What is the one area of a boat transaction that is the most contentious in your experience as a yacht lawyer?
Inventory and exclusions.
What is the one clause in the purchase and sale agreement that everyone should read twice?
Well, it seems simple, but the answer is the delivery location. It can have profound economic effects on the buyer and the seller. And if you don't get it right, you could subject yourself to a lot of expense.
What is the deadline to reject a vessel under the MYBA contract?
24 hours after the sea trial and 7 days after the survey.
And between the IYBA and the MYBA contract, which one is more flexible for cross-border deals?
The IYBA.
Hi, everyone, and welcome back to Full Displacement. This is the Current Yachts podcast, and we're here today to chat with Chris Anderson. Chris is with Robert Allen Law, and it's one of the firm that worked together with the IYBA, that is the International Yacht Brokers Association, to craft and draft the documents that a lot of yacht buyers and sellers have seen or will see as part of their transactions and dealings with brokered boats. Without further ado, welcome back, Amanda, and welcome, Chris.
Thank you.
Thank you,
Good to be
Marilyn.
here.
We're happy to be here today.
And we've prepared some really dense questions for Chris, so I'm hoping that you're ready for this conversation. It goes pretty in-depth, but this is super important. As you all know by now, the devil's in the detail, and I think Chris will help kind of shine that light on some of the portions of these documents. And today, we're going to talk more specifically about the purchase and sale agreement so that you understand as a layperson, a buyer, or a seller, what are some of these technicalities behind the verbiage that was chosen and what to look for in a purchase and sale agreement. Before we get started, I'd love to hear a little bit more about you, Chris. How did you join that law firm? How did you choose yachting? And are you a boater yourself, Chris?
Well, my uncle had a 44-foot Viking back in the 1980s. He kept it in Atlantic City, New Jersey, and so we'd go down and spend the weekend on the boat. And it was definitely the highlight of the year whenever we did it, And it was 44 feet back in the 80s was a huge boat back then, And now now it's the size of some of the tenders I work with, but it's
Yep.
times have changed, I'd say, for the better. Yeah, so I'm now the proud owner of 2 kayaks, which which I love. But that's the extent of my current boating. But I love it. I love the industry. I joined Robert Allen Law almost directly out of law school. I went to law school at University of Miami. Go Canes. And I joined as a corporate attorney. And so one of our big clients was Bertram Yachts, which was a big sports fish manufacturer based in Miami. And they actually manufactured their boats in Miami. Many people remember on the Miami River. So we started, Bob was working with Bertram Yachts. Bertram Yachts was acquired by the Ferretti Group. We went on to represent them in the United States. They acquired Allied Marine. And so from there, we grew into really one of the largest law firms in the US and really the world that works in the yachting industry. So my primary practice area, while I started off kind of representing the manufacturer side, I'm now almost exclusively buyers and sellers and some banks as well. So that's what I do. I help people buy and sell boats and try to keep them out of trouble.
And Chris, I know you're here to explain the purchase and sale agreement to us today, but you also have expertise in the tax advantages. Is that correct?
Well, I know a lot, and I know enough to be dangerous.
Okay.
We have a tax attorney on staff, or we can recommend a good tax attorney. The tax law when it comes to boating is it's its own beast, right? So certainly we advise clients, and a tax attorney needs to work in conjunction with a maritime attorney such as me, because the boat needs to be able to charter, and there's a lot of as you guys know, there's a lot of requirements needed for a boat to be able to charter, particularly in U.S. waters, which is one of the requirements to claim bonus depreciation and taxes.
Yeah, absolutely. So that's just another side thing that you can contact Chris for in the future if you needed it.
Happy to help.
Actually, one of the things that we wanted to cover today is the key differences between what we know and use most in our current practice of representing buyer sellers at Current Yachts, the IYBA purchase and sale agreement, and compare that to the MYBA, the memorandum of agreement. And those are slightly different. And we're going to go through those now to really fully understand what may be more favorable in a particular situation for a seller or a buyer. So the first question I have in this area is time is of the essence. Can you explain this to us, Chris? Break it down in plain English for our audience and how come it's in that MYBA agreement, but not in the IYBA purchase and sale agreement?
Absolutely. And this is one of the many differences between the two contracts, but it's an important one, and it's really something that the IYBA Forms Committee thought a lot about before we decided to not include the time is of the essence provision. So a time is of the essence provision means that a deadline is a deadline. There's no wiggle room. There's no outs. There's potentially, if there's a force majeure, which is, if there's a fire or something like that, then, then that could be wiggle room. But absent something like that, if you don't meet the deadline under the contract, then you're out of luck, right? You're in default at that point in time. So the IYBA does not. IYBA means International Yacht Brokers Association. It's an international brokers association based in Florida, but works across the world. So I'll say the IYBA PSA, and IYBA PSA means IYBA purchase and sale agreement. So the IYBA purchase and sale agreement does not include a time is of the essence clause. And the reason why is that the Forms Committee decided the job of this agreement is to get boats sold, right? Bought and sold, right? The purpose of the agreement is not to try to trip up a buyer and create a lawsuit that, that the seller now has a right, or the buyer now has a right to sue the other party, right? Because of a technical default. So, it can be a double-edged sword. It can help in certain situations to have the time is of the essence clause. In other circumstances, it really doesn't make any sense. IYBA took the position that on average, let's get boats sold, don't include it.
My understanding is most real estate transactions, for example, are a time is of the essence scenario, which is actually not the case then in the majority of, let's say, the average boat sale using that IYBA PSA. So that's a key difference for people to understand. It doesn't have the same sense of urgency, and it has a little bit more leeway in yacht sales under that PSA from IYBA.
Yes. Yeah. Certainly, I mean, boats require a little bit more flexibility sometimes. Sometimes you need to get the boat to the Bahamas, slow getting there, right? If you don't get there by the delivery time, then you don't want to have the deal blown up because of that technicality.
So that's a real world scenario saying, okay, the boat needs to be surveyed by this date, but a reason prevented the boat from getting to the haul out yard. And of course, you don't want to jeopardize the crew or the ship in the delivery there to get it there by an arbitrary date that says if it's not, the deal is dead. Is that one of the cases where this is important, or?
Yeah, absolutely. So in that case, if there's damage to the boat, like I said, there's what's called the force majeure provision that exempts performance in the event of an act of God, something outside of the control of the parties, right? So that would probably make more sense there. It just takes some time. You're missing a crew member, then that's where the time of the essence clause and not having one really allows for some flexibility. So in real life examples, I've been on both sides of this issue, right? And it, like I said, it's a sword that cuts both ways. So one example, I was representing a buyer. Boat was in Hong Kong. The seller was in Hong Kong. American buyer. We had the funds in our trust account, and we wired them 24 hours before closing, and we had a MYBA MOA there. And again, that's the Mediterranean Yacht Brokers Association Memorandum of Understanding. So under the MYBA MOA, there's a time is of the essence clause, and so the wire wasn't hitting. There were time zone differences. I didn't sleep for 24 hours because of the fact that there was a time of the essence clause there. We certainly would have had arguments. The fact that we did wire the funds well before the deadline. Our bank was saying it wasn't in our account. Their bank was saying it wasn't in their account. Anyway, it was, anyway, the time of the essence clause certainly added a lot of stress on my end in that closing. I wish I had been dealing with the IYBA at that point. But on the other side, I represented a buyer here in the States, a really pretty straightforward deal, American seller as well. But the seller was represented by an attorney who I will not name, but the seller completely blew past the closing deadline, right? There was a closing date. The seller's attorney just didn't respond for the week before closing. And so there was a closing date, and we're asking, well, where are the bills of sale? Where's the paperwork in order to transfer title to this boat? And we didn't have anything. So you can still default the seller in that case, but it's if the seller has the right to cure, essentially, because of the time of essence problem. So that's exactly what the attorney surfaced the day later. He says, no time is of the essence clause. We still have a deal, and we're here are your bills of sale. We're going to close. And so my client wasn't exactly happy with that situation. He'd already had a captain lined up. He'd had insurance lined up. He was paying the per diem costs of yacht ownership, but he didn't have a boat. So he was pretty angry. But ultimately, the IYBA contract got the boat sold.
Right. And that's the main goal. It's just in how much do you want to put certain parameters around things? And each one of these contracts does and does not put these parameters around. One of the ones we ran across just recently was the deposit deadline, basically a delay in that. Can a delayed deposit be ground for termination in the IYBA contract?
So yes, it can. The IYBA contract, there's a little blank. It allows the parties to fill in how many days after the contract is signed that the parties have that the buyer has to make the deposit. And if they don't fill in a date there, then it's 3 business days after the contract was signed. And the buyer has to wire in the funds. If the buyer does not make that deadline, then the seller does have a right to default the buyer. The seller can also prohibit a sea trial and survey from moving forward. And the seller has a claim against the buyer for the amount of the deposit that was not paid, plus attorney's fees, right? So the idea here, again, the forms committee thought a lot about this one, and we talked a lot about this one. And the idea was, we want deposits under the contract. We want to make sure that we have real buyers that we're working with here. So they tried to put a lot of teeth into it. There's no time of the essence clause. So if there's a 1 to 2 day delay there, then you can still default the seller, but they have the right to buyer. They have the right to cure.
If I translate this in everyday terms, what you just said to us, Chris, is, with the understanding that maybe a wire transfer takes an extra day to clear an account, it is actually quite reasonable and in fact possible for that seller to have claim to that unpaid deposit plus attorney's fees for a signed PSA that didn't come with any deposit. In other words, you can't just go around signing PSAs and not sending deposits because you're going to be in trouble as a buyer. You got to be real. You got to send the money across, and not sending money doesn't just void the contract. It puts you on the line, correct?
Absolutely. That's the idea. Yeah.
Thank you for clarifying this.
In these smaller contracts that we're working with, the people will sign a PSA and then just be like, I never sent the deposit. Too bad. Now, of course, the attorney's fees and going after them for damages is one thing that you have to choose. Okay, do we want to go down this road? But in the instance where a 10% deposit has already been cleared, and then the rest of the money doesn't show up, that's where the contract in the IYBA says that there's every right for that seller to keep that 10% deposit if the rest of the contract doesn't move forward. So how is this different in the other contract, the MYBA contract?
So the MYBA contract, it sets the deposit, right? Under the IYBA, you have the right to select the amount of the deposit, right? It's typically 10%, but the MYBA says it's 10%, right? And you have to make that within 4 business days of when the contract was signed. The MYBA contract actually has less teeth in this provision than the IYBA. So the MYBA contract says that if the buyer doesn't put up the deposit, then the seller still has the right to cancel the agreement, but the seller can only go after the buyer for its out-of-pocket costs, right? So attorney's fees, anything, which are pretty low typically at that point of the transactions. They don't have the right to go after the deposit itself, right, or the amount of the deposit itself. The other thing that the MYBA differs is that the seller can terminate the purchase and sale agreement, which obviously terminates the right to do a sea trial and survey, but it doesn't specifically allow the seller to prevent the buyer from going through with the survey and sea trial, right? So the only way the seller can move forward is to terminate the contract, right? They don't have the right to prevent the buyer from conducting this survey and sea trial unless they terminate the contract.
And that has to be in writing.
Yes, yeah. You'd have to provide written notice of termination.
Termination, right? Yeah.
And another key difference too that you've highlighted several times because you've been sharing knowledge in the industry about those key differences, right? Between the IYBA PSA and the MYBA MOA, Memorandum of Agreement. Another thing that's very different is the acceptance process for a vessel. And can you perhaps talk us through that so we understand the key differences between the two agreements?
Absolutely. So I've been a lawyer for 20 years, and I still have to go back to my notes every time I look at the MYBA acceptance process because it's so complicated and it's changed a little bit over the years. So anyway, the IYBA is straightforward. The buyer and the seller have the opportunity to pick a date by which the buyer must either accept or reject the vessel, and that's called the accept-reject date. Prior to that, the buyer has the right to inspect the vessel, do whatever it wants in terms of surveys and sea trials, can elect not to do survey or sea trial. The buyer can do a personal walkthrough of the vessel. And if the buyer doesn't like the smell of the boat, it doesn't like the color of the carpet in the master stateroom, then the buyer has the right to cancel. So unless the buyer affirmatively accepts the vessel before the accept-reject deadline, then the contract is deemed terminated.
Under the IYBA purchase and sale agreement, the buyers have broad discretion to reject the vessel. And I was wondering if you've seen cases where this has been used, strategically, and you're like, okay, that is an interesting way to apply this. Do you have examples of things that have been either surprising or creative in your experience that you could share with us?
Yeah. So one of the things that is technically permissible under the IYB PSA is to put in an offer on more than one boat, right? For a buyer to put in an offer on more than one boat. The IYBA is a option contract, and so it allows the buyer to walk away for any reason unless it accepts the boat, right? So we have seen examples of buyers putting in offers on more than one boat. They play the offers against each other. I don't think that this is best practice. Choose your boat and and work on that one. But it is discouraged typically in the industry, but it is technically possible. The key there, obviously, though, as we discussed, is you got to make a deposit on each of those contracts. Otherwise, you can't just have one deposit for two contracts. It needs to be two separate deposits for each of the contracts that you put out there.
That's a really good reminder, actually. Wait up. You can't just pretend you have a deposit. It has to be for that particular vessel. So very good point. And we get asked the question a lot as to whether or not somebody should or could pursue two different boats. And perhaps, Amanda, you can speak to that.
My encouragement there is choose your boat, like you said, Chris, and work on one and not try to say, well, which boat can I get for the cheapest price? And my thing is, if you put the contingency in there of personal inspection, you're allowed to have a personal inspection. And if you don't like the smell of the boat, like you said, you could reject it. But once you put contingency of survey and sea trial, you're on the hook for paying for that. And that is assurance to the seller as well that you're willing and ready to move forward. So it's just one more protection in both ways.
Absolutely. So, and I'd also say, that differs from the MYBA. MOA, I'd never recommend a buyer put in more than one offer on more than one vessel under IYBA MOA. So we didn't really get into that, but the IYBA MOA, it almost presumes that once a buyer signs the MOA, that the buyer is going to move forward with the deal and buy the boat, right? The bar for a buyer getting out of the IYBA MOA is much higher than a IYBA PSA. So under the MYBA MOA, buyer and seller choose a date by which the survey and sea trial must be completed. The buyer first does a sea trial of the vessel, and then they have 24 hours upon completing the sea trial to either accept or reject the vessel.
24 hours? That's it?
That's it. And yeah, and it's if they miss that deadline, then they're deemed to have purchased the boat, right? That's a deemed acceptance.
So
So
it's a
it's
default
their boat.
acceptance with the MYBA agreement.
Absolutely. Yep.
Okay. So you
Yep.
got to know what you're doing. If you're looking to buy a boat, make sure you know which agreement you're working with and ask all the questions, especially if it's MYBA, because the outs are very limited, it sounds like, post-survey,
Very
right? So
limited.
that 24-hour expiration means you're going to closing.
You're going to closing. And then then after the sea trial, then they do a survey, right? A condition survey. And after the condition survey, the buyer then has 7 days in order to get out of the deal. But the bar is much higher. It's not just, they can't just get out for any reason. They actually have to have a surveyor certify that there's a defect in the operational integrity of the vessel or its systems or machinery. Frankly, as we know, a lot of surveyors find a lot of issues, right? So it's not necessarily that hard to meet that bar, but I've been in the position where the seller is able to argue that's not a defect, that doesn't affect the operational integrity of the system. To use our prior example, the color of the carpeting at that point, that's not a defect, right? Under the MOA. It's also not a defect if you don't like the smell of the boat. That's your boat, unless your surveyor certifies that there's a real defect with the operation of the vessel. So it's
Yeah, that's very interesting. I didn't realize how strict it is, but I can see
mhm.
how for certain vessels, certain assets, it makes sense to go that route. And
Yeah.
fair point.
Another clear difference is in the IYBA PSA, the buyer doesn't assume risk prior to the closing. His risk is the 10% deposit held in trust that he can get back at any point before that accept reject date. Whereas MYBA, how does that differ? You said basically once they sign that PSA, it's like they're buying the boat. Where's the difference there as far as risk goes?
Yeah, so back to our previous example. So first of all, you have your sea trial, and then, say you miss that 24-hour deadline after the sea trial, that's your boat, right? Then you go to the survey, you have 7 days after the survey to present that certificate from your surveyor that there's an actual defect in the systems. And if you don't deliver that within 7 days of the end of the survey, it's your boat. You've deemed accepted it, right? There's always the possibility that at that point, the seller could say, no, this is not a legitimate defect, right? We've had that. We've had,
Sure,
it was
I could see that.
a $50 million deal, right? And we had a seller saying, no, that's not an actual defect. And, and that means, the buyer had 10% deposit down, that's a lot of money that's on the line just because of the way that the MYBA sets that up. Like I said, it has the presumption that once you sign the contract, you're going to buy the boat unless you have a really good reason not to.
But again, when we go back to risk and insurance coverage in this case, if something happens to the boat between the survey and the closing, that coverage is still under the seller's insurance, correct?
Yeah. So under both contracts, risk of loss remains with the seller until delivery occurs, right?
Right. That's
Until
what I
until
wanted to clarify
closing.
based on the way Amanda worded her question. I want to make sure that that was clear. And do both agreements then prohibit the sellers from using the boat once the survey has been completed?
Yes. Yeah. Yes. Both agreements have similar language. No personal use after the survey. I mean, that's something you should let your seller know that they're signing up for, because we constantly have sellers that are surprised by that provision. I have an anniversary party that I want to throw in the boat, and it's the day before
Farewell
closing.
party, no such thing.
Yeah, exactly.
And based on the differences you've highlighted so far, where would you say most brokerages draw the line as far as which agreements to use? Does it matter more based upon region and location of the vessel, or more so really its price point threshold? What do you see?
So, I do see both. I'd say primarily it is based on geography. The IYBA is historically a Florida-based organization. IYBA contract is more commonly used in the U.S. and Caribbean transactions. The MYBA MOA has been around longer. And for that reason, it's more widely accepted in European waters. And just due to the age of the organization, the Mediterranean Yacht Brokers Association, you tend to see larger deals done on the MYBA MOA rather than the IYBA PSA. But that's in my experience changing. You'll see a lot of European lawyers now who actually do a heavy markup of the MYBA MOA and bring the provisions closer to that of the IYBA, just because it's a little bit more clear and less convoluted than the MYBA MOA.
Okay, yeah. Thanks for sharing that. I mean, there's really very few people we could ask this question, so we really appreciate those insights on that particular point. So super, super valuable.
Absolutely.
So let's go to the next portion of the contract that covers inventory and exclusions. Obviously, a lot of the times people are looking at the listing online and they see the inventory listed there, but there are sometimes exclusions, buyers' personal effects, that CBOB that they want to bring with them to the next boat doesn't convey with the sale. Inventory seems like a small detail, but can cause big disputes down the road. What is the most common issue you've seen here regarding inventory and exclusions?
Absolutely. So this is one of the areas that we see kind of the most disputes, I would say, in a transaction. For background, the IYBA agreement says that in terms of inventory, everything that was on the boat or in the listing agreement, if something's listed in the listing agreement, that's on the boat at the time that the purchase and sale is entered into, is included with the sale of the boat, unless the seller delivers an exclusions list. And the seller has 5 days from contract signing to deliver an exclusions list to the buyer of items that are excluded from the purchase. The MYBA MOA, on the other hand, how they handle it is you have everything related to the boat or used with the boat is included. And then the parties sign I think the seller has 7 days I have to check that, but the seller has 7 days to deliver an inventory to the buyer. And then the parties go ahead and they initial that inventory post signing of the agreement. So there's a lot of room for issues here, and one of the main ones that we see is certainly high value items. There are tenders or chase boats that are excluded. It's one thing just because of the way the contracts are set up. It's assumed that a tender or chase boat would be included in the purchase, but then you deliver a exclusions list 5 days later that excludes that item, and it's possible that the buyer is super angry at that point in time because he thought he was paying to include that tender, and it turns out it wasn't included. So for both, when I represent both buyers and sellers, I always specify in the contract when we're getting started, what tenders are included, jet skis, if anything, are included, any artwork or sculptures that are included. The other areas where this kind of becomes a little tricky is, for example, offsite storage units.
Yeah.
Yeah, I don't know if you guys have dealt with that before, but so under the IYBA PSA, it's only items that are aboard the boat that transfer. Under the MYBA, it's everything that's used in connection with the boat that transfers, right? So under the IYBA, offsite storage items don't transfer unless you specifically write into the PSA or into your acceptance that that those items are included. Under the MYBA, those items are included unless you actively exclude them, right? And neither deals with what happens with the lease, right? So, so there's always the question, do you just leave them there? Do you have to bring all those items to the boat? So that's always something, again, that I try to address up front. And then the last area is leased items. So for example, primarily in Europe, it's pretty common to see IT systems and AV systems that are leased. Right? So that means that as the seller, you need to make sure that IT system is excluded from the purchase, right? Otherwise, you've committed to transferring somebody else's property, right? You don't own, you as the seller don't own that IT equipment, you can't agree to transfer that to the buyer, and then the buyer is going to be really angry at closing when the IT system isn't included in the purchase, and they can't send an email until they have a replacement in place. So those are just some of the issues that we see. And like I said, I like to get out ahead of it, and that's my policy. I Section 15 of the IYBA has an additional terms section, right?
Yeah.
Either included in there or attach an addendum, and clarity prevents conflict.
Another
Yeah.
thing that we do that's pretty standard at Current Yachts, whenever we take on a listing, we actually, as part of our listing agreement, have a custom addendum that our sellers complete, and it's both a owner certification and condition disclosure. So we make sure that this is included and shared with the buyer when they present their offer. So there is not going to be further negotiation on those terms. And at that point as well, of course, the list of exclusion inclusion. So it's very transparent, very clear. We don't wait till the last minute to find out, oh, wait, we forgot to disclose. We make our disclosures and owner certification from the get-go. And we find that that's most successful.
Yeah, getting in front of it is the
Absolutely.
best advice that you had. And that comes for us when you sign the listing agreement with us,
Correct.
that we can make
Exactly.
this apparent to any buyer coming to the table saying, oh, yeah, that code 0 that is in the storage unit, it's not on the boat right now, but it will be by the time the survey is there, so it can be yours. Or by the way, this C-Bob or this lift electric foil that you thought came with the boat, it's not, it's going on the next charter with the owner. So we have to be very specific on these things.
Yeah. Yeah. Prevention is worth a pound of cure. Is that the saying? I don't know. Something like that.
Yeah,
Yeah.
exactly.
Yeah.
An ounce of prevention, pound of cure.
And I think important too to coach our clients as well. You don't want to tempt questions and negotiations on items. So just remove the items off the boat prior to any showing to avoid any temptation to negotiate or request something be added with the boat. Hey, will you throw this in? No, I'm not throwing anything in. So that would be my recommendation too for sellers.
Absolutely. Best practice.
Recently, we ran into this one about your choice of law and dispute resolution venue. IYBA, which we choose to use with Current Yachts, offers multiple arbitration venues and which way the parties want to choose to come a dispute. What are the pros and cons of arbitration in places like London versus Fort Lauderdale, would you say?
So, well, to back up, the IYBA agreement, it includes as a default arbitration in front of the International Yacht Arbitration Council. IYAC is the term there, and the IYAC is to my knowledge, the only arbitration forum in the world dedicated to yachting. Right, there are a number of maritime arbitration associations out there, but they deal with the big cargo ships and cruise vessels. Yachting is not what they do. And as we know, yachting is very different from commercial shipping. And so I love the fact that the IYBA PSA defaults to IYAC arbitration. I think it's smart to have yachting disputes arbitrated by arbitrators that know about yachting. So that's first. The IYBA also allows for a choice of, say, the parties don't want IYAC arbitration. They can also go to the courts. They can also do London Maritime Arbitration Association, which is kind of a very old and traditional arbitration association based in London. They have that option, but IYAC arbitration is the default. And then, though, based on where the parties live, IYBA wanted the purchase and sale agreement to be a document that could work in a bunch of different scenarios, right? If you have a buyer and a seller who are overseas, then sometimes they may prefer Monaco arbitration or London arbitrations. The IYBA agreement allows all three choices, either Fort Lauderdale, London, or Monaco, with Fort Lauderdale being the default. I'll say in my practice, if we're signing an IYBA PSA, 99% of the time, the parties just agree to the default provisions, which are, again, Fort Lauderdale and IYAC arbitration.
Yeah, we recently ran into an issue with an IYBA contract signed with London Maritime Law, and it caused some hiccups for us and some headaches, but we eventually took care of it.
Yeah, when you're talking about going overseas for arbitration or court, it can be very expensive. I mean, any litigation can be very expensive, but particularly if you have to travel overseas, you have to fly your experts overseas. That was the idea of the IYB PSA, to give as much flexibility to the parties as possible.
Yeah.
I'll contrast that with the MYBA MOA, and the MYBA MOA only has LMAA arbitration, and that's where they have the English barristers, you have the Queen's solicitors. So it's very formal. It can be very, very, very expensive. So that's the only option under the MYBA MOA is LMAA arbitration in London. So, for example, we represented an American buyer signed a MYBA MOA. The seller was also an American seller, right? But the two parties, and then the boat was in the Caribbean, the parties had to go over to London to arbitrate their dispute, right? It was really a nonsensical outcome. The buyer and the seller actually lived in the same town in Florida, but they had to go all the way over to London to arbitrate their dispute. So that's again, the why the IYBA wanted to allow a little bit more flexibility there.
But it's a very important call out because, again, for our listeners here, remember the offer will be presented by a buyer or their buyer's agent. And you need to be very careful as the seller, together with your broker, to ensure that the law, the jurisdiction matches your interest. Because if there is a checkbox or an information filled in a field that you missed, it could have very serious consequences. So if there's anything you take home from this conversation today, it is when you receive a PSA, ensure you know exactly what it says, because again, too important to ignore and actually pretty easy to miss because it's kind of buried in there, right?
Absolutely. Yeah.
Point taken. So switching gear a little bit, wanted to ask you, when you're advising a first-time yacht buyer, which agreement do you typically lean toward and why? And I think I kind of know the answer, but if you could summarize for us, make sure we really drive this one home.
Yes. Well, full disclosure, I am biased. I am part of the forms committee. I was a young lawyer on the forms committee, so I did a
Okay.
lot of the I did a lot of the drafting. A lot of the words that are on the page are written by me, right? So I have
It's your fault.
it's my baby a little bit, but but it was very much a group effort. But I worked very hard on it, and so I am partial to the IYBA purchase and sale agreement. But I also think, for good reason, I think it's a better contract. I think it's written more clearly. I think there's less loopholes and there's less traps that buyers and sellers can fall into. I think it encourages getting a deal done rather than having a series of potential pitfalls where a buyer is buying a boat that they don't want, or the seller is the seller can also end up in a lot of inadvertent trouble under the MYBA as well. I just think it's a better agreement for buying and selling yachts.
Okay, very good. And then for experienced buyers or larger yachts, would you say that then let that geography drive more of the decision based on what you told us earlier?
Well, as you mentioned earlier, the choice of contract is often driven by the buyer.
Right.
And on these big deals, and on really any deal, right? You don't want to ruin a deal because you insist upon another form of contract. You
That's
want
a
to
very good point. Yeah.
you want to work with your buyer, or vice versa. If the seller insists upon a MYBA and you've submitted an IYBA, you don't want to kill the deal over a form of agreement, right? So you can work with both agreements, but certainly a more experienced buyer is probably going to be a little bit more familiar with how yacht transactions work. But it's still at the same time, I don't know about you guys, but it seems to me that when these otherwise brilliant businessmen go to buy boats, right? Their minds just go out the window. It's a toy and not a multi-million-dollar contract, which it really is.
And unfortunately, Chris, what we're seeing now with the advent of AI, people are taking these contracts and then changing them with their own AI and demanding these things. And this is another thing that I caution in both the buyer and seller relationship. If a person is being a stickler when it comes to the wording of contracts, just beware that this person may be more litigious than the next. And if that's the way you're going into a contract, it's just one little flag, not red flag particularly, but a flag that's in the back of my mind of, all right, if this person is being a stickler on every bit of wording here, going through every document and saying his chat GPT is, smarter than the IYBA who has been doing this for years and years and years, that is a caution in my book that I make the seller or buyer aware of right away. And saying this person, if you enter an agreement with them, may be more litigious than the next. And beware.
And it's amazing the amount of false and bad information that's out there. I mean, I get summaries and addenda all the time that are generated by AI. When we're up against, when we have a counsel on the other side that are yacht lawyers, right? It's a small industry. We all know each other. Things go really seamlessly. And then below that, you have another lawyer on the other side who doesn't practice maritime law. Then it's you have to do your job and theirs. And then certainly if they don't even have a lawyer, they just have AI. Then
They just have AI.
your job is just became that much bigger.
A lot of the times I just go back to the default of, hey, this contract was written by industry professionals to cover both sides, and I am not comfortable changing the specific details of this contract unless it's going to blow up the deal. And I can't tell you times, that we've defaulted to that statement. Go ahead, Marilyn.
Another comment on this is just simply people aren't reading. They're coming back and making requests for things that are already addressed. And we have to educate because sometimes, to be honest, their brokers haven't read that document in a while either, and they don't realize it's in there. And so I really encourage all brokers, of course, when you get some verbiage back from a client, before you flip it off to the other side of the table, take a look at it. Is it really necessary? Is that going to make things more complicated? So that would be kind of what I've learned from that one example where somebody was trying to rewrite the rules and we're like, everything you wanted is covered in here. Anything that you want separate, we can make a request, but the client ultimately has a choice. And I wanted to bounce back on something that Chris said, which is put yourself in the seller's shoes. When a seller receives an offer and that seller is in Florida and he receives two otherwise identical offers in terms with two different agreements, which one are they more likely to choose and prefer? Probably the one that they're more familiar with, the IYBA, which perhaps is more common, that perhaps their broker based in Florida might be more familiar with. There's no right or wrong answer. It's all about what makes sense for that particular deal. And so I really appreciated that comment from Chris on saying, hey, what do you think is most likely to win? So think about that as well as the terms.
And to your point, make sure you understand what you're signing and read it thoroughly. Read it. Yeah.
Yeah.
That's really important. Again, goes back to real estate, right? When you sell a house or you make an offer on a house, you read the terms and you ask your real estate agent all these questions. Do the same with your yacht broker. That's why we're here. Ask us. Don't ask AI.
Yeah.
And if we have a clarifying question, we go to Chris. We go to other specialists for their particular lane. Everybody stays in their lane. We're here to make the deal go through, support our client's interest, and we don't have the answer for everything, but when we need support, we know where to turn. And so for that, thank you, Chris, for everything you've done for IYBA and that particular PSA. This is what we use mostly because we have most of our inventory here in the US and the Caribbean, but it's working. You just need to know what it says. And then if you have questions, know who to ask.
Absolutely.
So thank you for watching this episode of Full Displacement with Chris Anderson today from Robert Allen Law. We're going to put the contact for Chris in the description of this video. There'll be a link to our marine directory. This is where Concurrent Yachts gathers all of the contacts that we have made in the industry for vetted professionals that can help you as a buyer or as a seller. Again, thank you, Chris, for your time. We look forward to having you in the future on the podcast. If more questions arise, so please post comments below, and we will see you on the water. Fair winds.